Good day guys! Today, we shall continue the series of lecture videos for criminal law. Ang mga lecture videos na ito shall only be short, yet compact, and direct to the point. We shall only cover the salient topics and provisions of the Revised Penal Code, various jurisprudence, doctrines, principles, and selected special penal laws. This lecture series can actually be used by criminology, political science, and legal management students. However, all students who are taking up criminal law and all those who want to learn about the criminal laws are very welcome here in our lecture series. For this lecture video, we shall discuss the principle of pro reo. So let us now start our discussion. To begin with, we should know that it is a basic rule in statutory construction of criminal laws that in case of doubt, it should be resolved in favor of the accused. The basis of this construction is the principle of pro reo. Literally guys, in dubio pro reo means when in doubt, then rule for the accused. The term in dubio pro reo first appeared in the Roman legal system in the work of Egidio Bossi in 1566. It is actually a rule for deciding criminal cases. The basis for the use of the term is given on the condition of the existence of a presumption of innocence, which means if there is more than one interpretation of the law, then the one that should be chosen is that which is favorable to the accused. Since there exists a presumption of innocence which is rooted in this principle, ang isang defendant may not be convicted by the court when a doubt about his or her guilt exists. You have to remember guys that the quantum of proof for criminal cases is proof beyond reasonable doubt. Hence, kapag ang prosecution fails to prove the guilt of a defendant beyond reasonable doubt, then the accused must be acquitted in a criminal case. Closely related to the in dubio pro reo principle is the rule of lenity. This rule applies when the court is faced with two possible interpretations of a penal statute. Yung isang interpretation prejudicial to the accused at yung isang interpretation naman is favorable to him. So ano ang masusunod sa kanila? Take note of this. The rule of lenity calls for the adoption of an interpretation which is more lenient to the accused. An example of which is the case of People versus Temporada. This is a case wherein the accused Temporada was found guilty of the crimes of illegal recruitment and estafa by the Regional Trial Court of Manila and the Court of Appeals. However, in this case, opinions differ sharply on the penalty that should be imposed on the accused appellant for estafa. In particular, there had been a debate on how the indeterminate sentence law should be applied in a case like this where there is an incremental penalty. In a separate opinion penned by the late Justice Corona, he argued that jurisprudence shows that there are two schools of thoughts on the incremental penalty in estafa vis-a-vis the indeterminate sentence law. The first school of thought is more favorable to the accused, and the second one runs contrary to the principle of pro reo. It also violates the rule of lenity. Hence, What was imposed as penalty to temporada in this case was derived from the application of the first school of thought since it is more favorable to her. So guys, this ends our discussion for the principle of pro reo. I am Ian Gonzalez telling you, alamin natin ang batas upang hindi tayo mamuhay ng marahas. See you again next time. Thank you and God bless.